because there will be an appeal in this case most likely, and so I need to make sure.
Sir. Thanks. Yes, you may.
Good afternoon again, ladies and gentlemen. I'm going to be quick, so put on your seatbelt for that. First of all, I agree with Mr. Pepperman that the self-serving suggestions by Real Water, those numbers, I've never understood how someone else can tell you what your injuries were. This is the first time I've seen, the first case I've ever had, where the person, one of the people who caused the injury, actually suffered the same fate, except not to a severe degree. And they told you what it was worth. What's weird to me, and what's disingenuous to me, is that Real Water, Hanna, and Milwaukee are saying, believe the good things, the things that help us from our own witnesses, but if they don't help us, don't believe them. That's what they're telling you. When Blaine says, you know, the meter works sometimes, they said, oh, great, we love Blaine's testimony. But when Blaine tells you, I wouldn't take $10 million to go through that again, oh, don't believe Blaine. Don't believe Blaine. When Mr. Mendigana, when Mr. Bush, when they all say that meter was inconsistent, oh, don't believe Mr. Bush, don't believe Mr. Mendigana, don't believe Ms. Converse. But when they said, well, there was times when it was okay, oh, they embraced those witnesses. I'm disappointed because perhaps when you don't have the law, you argue the facts. And when you don't have the facts, you argue the law. But when you don't have either, what you do is you make it up as you go along. And that's what they've done. They've asked you to not listen to the evidence that you've heard, the mannerisms you've seen, Mr. Salvaggio, by example, Mr. Brown, Jason Brown, by example. Don't believe any of those things. You could tell the lack of credibility in those witnesses. It was obvious. But they want you to embrace the lies that help their position and then to ignore the testimony that, for some reason, doesn't support their defense. That's what they're asking you to do. Ladies and gentlemen, don't be fooled by that. Do not be distracted by it. Do not be persuaded by it. There's no support for their defenses, none. The other thing I would suggest, and I find it troubling, because we know that they have no evidence to support anything they've said in terms of numbers. Nothing. They point to the instructions, but the instructions tell you, use your judgment, your reasonable judgment. Now, why would you go against the evidence? Mr. Robbins got up and says, the evidence is not what I say, is not what Mr. Parker says, is not what Mr. Pepperman says, is not what Mr. Kemp says, is not what Mr. Odou says. Well, the evidence was what Mr. Blaine said. And he says, don't believe it. Do not believe Mr. Blaine, the person who actually provided evidence to you. He's asking you in one breath to follow the jury instructions, and the other breath, when it doesn't help him, he says, don't follow the jury instructions. Follow the evidence. And that's the only evidence you have of value from a person who actually sustained a similar, but to a lesser degree, acute liver failure. What I also found conspicuous is that Mr. Robbins and Mr. Rasmussen, they didn't want to talk about their instructions or lack thereof, or the lack of warnings. What they wanted to talk to you about was hydrazine and degradation. That is a red herring argument. The reason why degradation came up was because we wanted to demonstrate to you through the evidence that it was higher when the plaintiffs were drinking it. And by the time the tests were done, years later, it had diminished. That was the whole point of that testimony. So now they throw it up in your face, suggesting that that whole argument was one to suggest maybe they put more hydrazine in it because when they tested it with the orb meter, it had reduced. That is ridiculous. That is one of the worst arguments I've ever seen. First, because there's no evidence of it. No one said, you know, because it sat on the shelf for 2 years, we decided to take the odd meter back to it, test it again. We saw that it was lower and then added more concentrate. Have you heard anyone say that? No. The 4 steps included the odd meter. There was no later testing of the concentrate to see if the water, to see if the hydrazine or the concentrate had diminished. That's not what happened. They are making it up as they go along because they have no facts to support their defense. None. Ladies and gentlemen, this is an easy case. Shane, do me a favor, put up the first slide I have. I'm going to show you a couple of points really quickly. This is the user manual. And under the warranty, this is something that Mr. Salvaggio said. He said there were no refunds. Remember that? We all remember that, right? This is why there are no refunds. This warranty is limited to repair or free charge replacement of the instrument cannot be repaired, if the instrument cannot be repaired.
Your Honor, I think this is outside of the defense's arguments that were given. This is new stuff that was not presented during closing.
You know, they went right back to talk about the instructions and the warnings and the owner's manual. This is the owner's manual.
Yeah, Milwaukee has no objection.
I'll go along.
Thank you, Your Honor. This is the user manual. Do you see a warning in this user manual? Do you see an instruction in this user manual that deals with oxidation? There's not one, because they would have pointed to it if there was one. Next slide. This is the directions after they determined, this discusses the use of the conditioning. And go to the second paragraph. 5 to 7 days of acidic, very acidic water. Remember that was one of the options prior to this conditioning kit coming out? Then the conditioning kit comes out, and then they say, oh, go down, 45 minutes. See that? Next slide. Here is the tip card that Mr. Robbins loved waving around in front of you. To effectively read a negative ORP state of water, the platinum probe used in most ORP meters must be oxidized. Not out the box, because they originally said you could do it right out the box. 48 hours. Do not use a storage bottle for long-term storage, which was what Mr. Pepperman was just saying a second ago. Again, do you see any warnings or any consequences in this tip card that says, hey, if you don't oxidize it for this long, you may get inconsistent readings? It's not there. It is simply not there. Next. Now, here is an email, or a chat, I'm sorry, regarding a customer who's having different readings from the same liquid. The reason why we are here. Different types of water, including Kangen water. This goes to this whole argument they made about the fitness for a particular purpose. They knew that this meter was being used for waters, including, for different types of water, including Kangen water. And it says right here, to test different waters. And those are problems that are being had. Next slide, please, Shane. How can I get a negative ORP reading of minus 400 and above? Asking a question about it. The solutions that are recommended in the instruction manual. There are no instructions in the instruction manual for doing this. Plain and simple. I showed it to you just a moment ago. Then they talk about the ORP meter and the probes need to go to an oxidation process 3 to 4 days. Another different recommendation. Next slide, Shane. I'm sorry, go to the bottom of the last one, Shane. What I also thought was amazing about this is there's no mention of the tip card. So they're sending out a message. They don't reference the tip card that says 48 hours. They're giving a new suggestion which tells me the tip card doesn't work, the prior recommendations don't work. He's doing it on the fly, and we know, based upon the evidence, they didn't test this process or any other process. Now go to the next slide. Again, I think the probe on my MW500 may be faulty. I get very inconsistent readings and rarely get a negative reading on 9.5 Kangen water. I did the procedure with vinegar. He's telling this person at Milwaukee, where the company Mr. Robbins represents, that they can't get this thing to work. Next slide. Again, person's having a difficult time with the oxidation and conditioning process, 3 to 4 days. Mr. Robbins waved that tip card in front of you 20 times, knowing full well 48 hours doesn't work. It does not work. And if their warnings and instructions don't work, their product is defective. That's game, set, and match. And this is an admission. This is their admission saying that 48 hours does not work. It has to be 3 to 4 days. And that's nowhere in that tip card. Next. Put the full document in for a second. I want you to just see that Jason Brown's still in, he's the one involved in these chats, the second in control of Milwaukee, Mr. Robbins' client. Now you can blow it up. But this one I thought was important, very important. Do you remember in the warning box, the warning on the box that talks about you have to be a scientist or something, or laboratory procedures? Look at this. Good morning, I'm a dentist, and I'm going to begin using, whatever that word is, acid as a disinfectant. It would be helpful to be able to measure the orb of the solution. The measuring is going to be done on small amounts of liquid, approximately 1 liter at a time, by staff that doesn't have a scientific background. Any suggestions for a meter? Thank you. Mr. Brown says, I recommend the MW500 available on our site, includes this platinum probe. The unit is factory calibrated and only has an off and on button. Very simple. These are the selling points we're talking about here. So when they bring that box up and parade it in front of you, and Mr. Salvaggio wanted to talk about laboratory processes and all that other stuff, or practices, this is a dentist in a dental office asking for help, and this is the response. So when you hear Mr. Robbins and Mr. Rasmussen trying to throw real water under the bus to avoid the consequences of their own misconduct, this is their misconduct staring you in the face. Their own tip card is wrong. They said this is a simple machine to use. It's simple because it's always wrong. But this is what you have. Next slide. And then the coup de grace, Mr. Brown telling you, or telling this person, and by way telling you, that the MW500 is the best-selling meter by far. The meter that's 10% defective out the box. I don't think any one of us would get in a car or buy a car that's 10% defective, get on a plane that's 10% defective. Use a meter or a tire gauge that gives you the wrong tire pressure 10% of the time. That's what Milwaukee did. Now, if I could quickly go through just a couple of instructions, and I will be done. In terms of punitive damages, this is the part of jury instruction 47 that for some reason Real Water, Hanna, and Milwaukee did not discuss. Stop right there. Highlight conscious disregard. Conscious disregard means the knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to act to avoid those consequences. Couldn't be easier. When you fail the test and you fail to investigate, you know what the results are going to be. And that's all it takes. And that's what we have here. Real water failed the test. They've admitted it for hydrazine or any other toxin based upon this new approach. And Mr. Salvaggio testified that they never tested a single oxidation method, period. Go to jury instruction 30, please. If you find the warnings provided with the MW500 orb meter were inadequate, that's all you have to find. Defendant Milwaukee is liable to plaintiffs by a preponderance of evidence. Preponderance, ladies and gentlemen, like a butterfly landing on that scale if it was working. That's all it would take. A feather difference. 50.01%. That's it. Go to 29, please. Now I want to focus in on the second paragraph, because you'll get a chance to read the whole thing. If it fails to give adequate warning of such danger, a product sold without such warning is a defective condition. That's it. We already know, we have a concession here made by Milwaukee's own president. They don't have a warning in the tip card. They don't have a warning in the owner's manual. They don't have any consequences of failing to oxidize in either document. Finally, 26. 26, a product, though faultlessly made, is defective for its failure to be accompanied by suitable and adequate warnings concerning its safe and proper use. The absence of such a warning has rendered the product unreasonably dangerous. Very simple, ladies and gentlemen. The emails or the chat messages I showed you from Jason Brown, his admission that 48 hours in tip card wasn't adequate. That's it. And if it's not adequate, it proves that these warnings were defective and that meter was defective, rendering Milwaukee, in addition to Real Water and Hanna, responsible. We're asking that you check yes on every item in that verdict form. Not a single no. We're asking for all yeses. And if you strike yes, just to let you know, the punitive phase of this will probably be less than an hour. There's only one or two witnesses. We have only one witness. Our witness will probably be done in less than 20 minutes. The defense, to my knowledge, only has one witness. It would be a very short procedure or process. It can be done today, depending on what your desires are. It can be done tomorrow morning, whatever your desires are. Last slide, Shane, for one of the nail, please. This is an old favorite. For one of a nail, the shoe was lost. For one of a shoe, the horse was lost. For one of a horse, the rider was lost. For one of a rider, the message was lost. For one of the message, the battle was lost. For one of a battle, the kingdom was lost. And all for the want of a horseshoe nail. Quite simply, that means, for want of testing and investigations, the plaintiffs all suffered acute liver failure. For want of for proper instructions and warnings from Hanna and Milwaukee, the plaintiffs suffered acute liver failure. They wanted to throw in your face, oh, you know, we just didn't do this or we didn't do that. It wasn't meant, it wasn't purposeful. Their failures were purposeful. And the reason they didn't do it, the excuses they gave you, a little more time in terms of labor, or it didn't smell right if we put it in vinegar. You've heard a myriad of excuses, indirect lies, selling points over this trial, ladies and gentlemen. Please don't be taken or persuaded by it. Again, we appreciate your time. If there's anything I could say more than we appreciate it, I would. I don't think the words are adequate for everything you've done to participate in this process. Thank you very much on behalf of all the plaintiffs.
All right. And ladies and gentlemen, just 1 second. Counsel, can you approach? And counsel, thank you for your input.
Oh, thank you.
Okay. Well, ladies and gentlemen, we have completed the evidentiary phase of the trial, right? And we talked about this all the way through, and so now you're at the point of, when I say at the very end, you're not to really talk or express any opinion on this case until the cause is finally submitted to you. This is that time. Now, here's my question. You have to decide how you want to proceed, because, you know, we've been doing this collectively, right? And these are your options. You can take a break quickly and then go back and start your deliberation process. Now, understand this, I've never artificially placed time limitations on it, but if you want to stay here till late tonight, you can do that, or if you want to come tomorrow morning, bright and early at 9 o'clock, you can do that too. And here's my point, I want us to do it collectively, number one. Number two, just so you understand how the process works, if you decide you want to come back tomorrow morning, say bright and early at 9 o'clock, or it could be 8:30, or whatever time you want to come in collectively, you don't come back to court, you go straight to the jury deliberation room, and you sit and meet and you start the deliberation process. You understand that? That's how it works. So we're done with court. Just want to let you know that. Then the next time you come into court, you'll be reading the verdict, and then we're done. So any idea as to what you want to do, or you want to talk about it privately?
Your Honor, one other thing we failed to talk about.
Yes.
Oh, yeah. Yeah.
Wait, come here. 1 sec.
Yeah, I'm glad I caught it.
Process is in place.
Oh, perfect. All right, Joe, I just want to make sure.
Tomorrow at 9 o'clock.
All right, that's what we'll do. I just wanted to give you that opportunity to make that decision. And what's great about it, you have the entire day. You know, and so what we're going to do then, ladies and gentlemen, and as far as 9 o'clock, the outside of the courtroom at 9 o'clock, Marshal Sloan will come get you. You know where the jury deliberation room is, right? You know where to go, right? And that's what we're going to do. But last but not least, before I let you go, remember, you're admonished not to converse amongst yourselves with anyone else on any subject connected with this trial, or to read, watch, or listen to the report or commentary on the trial by any persons connected to this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember, and I told you this at the very beginning, when we first met, you can't do any independent research, right? Remember I told you, you'd be hearing from a lot of experts and things like that, and everything you need to know has come out during the course of this trial. So no independent investigation on any level, everyone understand? And last but not least, you're not to form or express any opinion on any subject connected with the trial until the cause is finally submitted to you. And so bottom line is you start doing deliberation. Let's go. I want to go, wait, I want to talk to you.
That was a good
Oh, that's my spare.
Oh, I was wondering. I was wondering whose
Well,
glasses.
they've been there for days.
Okay.
And last but not least, what we're going to do is we're going to swear the marshal and the matron. And ladies and gentlemen, these are the only individuals that will have contact with you. They have been sworn in. Raise your right hand.
This one is for the bailiff. You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed. So help you God.
I will.
This is for the matron. You do solemnly swear that you will keep these alternate jurors in some private and convenient place, that you will not permit any person to speak to them unless it is by order of this court, so help you God.
I will.
Thank you.
All right. And so anyway, ladies and gentlemen, I guess you should know, Sarah works for me. She's my law clerk. She graduated from law school and she's waiting for the bar exam results this week. Just so you know who she is. But anyway, in light of all that, I guess we'll see you tomorrow morning at 9 o'clock.
All rise to the departure of the jury.
Jury is clear, thank you, please be seated.
And maybe see, the last in council, we started on those, I don't know who the alternates are until tomorrow. And that's when they begin jury deliberation. Oh, absolutely. And then we take the alternates and we put them in a separate location, and we don't release the alternates until there's a verdict, so you understand that. And then last but not least, I do go in and let the alternates know what's going on, because I think I have to, because they can get frustrated. I just thank them. And I tell them they might get caught upon it for whatever reason, someone doesn't show up or something like that. And if that's the case, then we go next in line.
Thanks, Your Honor. Just a couple clarifications. Do they have a copy of the verdict form? You have a copy of the verdict form that'll go back?
They have everything.
Exhibit list, the laptops have been submitted. Okay.
I don't have the laptops.
Yeah, I need to take a look at them still.
Okay.
And here's an important issue, and Tori does a really good job at this. Here's her question. She says, may I have you see on the record that the exhibit list is okay to go to the jury? Anything we need to work on as far as that's concerned? Is accurate? And she says it's accurate.
Yeah, I think it's stipulated by the parties as well.
No objection, Your Honor.
Okay.
All right, and that's done. So, I guess there's no other issues right now, right?
We have the,
Oh, yeah, we need to get all your personal information.
have those three motions.
Okay, you know what we can do? All right, I think we're set up, and I guess we might as well get started.
One more.
Yeah, let's go ahead and set forth our appearances for the record.
Morning, Your Honor. Will Kemp, Eric Pepperman, and Teddy Parker, plaintiff.
Good morning, Your Honor. Joel Odou on behalf of Will Robbins and the lifestyle side comment for the water gold test.
Morning, I'm Scott Rasmussen, Brian Conley, on behalf of Hanna Instruments.
Good morning, Rob Robbins from Milwaukee Instruments.
And good morning, Your Honor. James Neale on behalf of UNFI on Blue Jeans.
Oh, Mr. Neal, how are you doing, sir?
Very good, Your Honor. I hope you are.
I'm doing good, doing good. Anyway, I see we have a couple of, we have, I guess, 3 motions that have been filed by, let me see, the defendants in this case. And we have also one issue that was raised by Mr. Odou in this matter too. And we'll just get to all 3 right now, all 4 right now.
Your Honor, we also have one thing we'll add at the end of this.
Yes.
Given that parties reserve their rights on these the 50A motions, we have one we want to raise with respect to Milwaukee. So we can address that at the end, Your Honor.
And we'll start out, I guess, first with, and I just had these in order as they were given to me. So there's really no preference I have. Put it this way. Mr. Rasmussen, do you have a preference as to what order you want to go?
Your Honor, if we do the third party complaint issue first, I think it's going to be quick and get Mr. Neal. Yeah, I don't think it's going to take very long.
Okay, well, I mean, if that's fine, we'll do it that way.
Okay. So Judge, on the third party complaint issue, there's been a couple developments since we were here before. I informed, with Mr. Neal's consent, I informed Mr. Odou that the plaintiffs, when they negotiated the settlement with UNFI, they took an assignment of certain of the proceeds that are generated, if any, from the Real Water Gold Coast policy. And I explained a little bit about it to Mr. Odou, that because of that thing in the settlement agreement, this doesn't happen all day, but because of that feature in the settlement agreement, and again, Mr. Belsky didn't sign it until Monday or Tuesday, so it didn't become operative to that point in time. But because of that feature in the settlement agreement, we, the 7 plaintiffs, need to be real parties of interest on that third-party complaint, obviously, because we've got a sharing agreement. So I have given Mr. Odou the proposed amendment that I've already given Mr. Neale, I think about 2 weeks ago. And basically all it does is it adds our names to it. There's no new claim made in here, there's no new factual allegation. It's just making sure we're in here. And I think it actually benefits Mr. Odou, because if we didn't add ourselves as third-party plaintiffs, you know, arguably we'd have another shot at the owl, okay? If he wins against Mr. Neale. And so what I've suggested is that we defer this until sometime next week, because Mr. Odou obviously has talked to his client about it. And I don't think it's a critical issue. You know, like I said the other day, my understanding was we'd be doing this third-party stuff later on after the verdict. I don't know what Mr. Neale's understanding was, but that was kind of my understanding. And then if you're invested, I think we should resolve it.
Okay, Mr. Odou.
Thank you, Mr. Odou, on behalf of Real Water Gold Coast. Your Honor, we have a couple of things that we wanted to just supplement to the record. Mark Zamora has a couple of things I'd like to show the court. If we could see plaintiff's motion eliminating number 41 and page 3, please. Thank you. So, Your Honor, this was the motion to eliminate we referred to in court the other day. This is plaintiff's motion to eliminate. The title is, motion to eliminate to preclude Real Water Tennessee, UNFW, arguments or evidence during plaintiff's compensatory and punitive damages phase. And as the court can see from page 3 of the motion, this addresses Real Water Tennessee. Nowhere in this motion is Gold Coast mentioned. Then if we can go to the PDF from the hearing on August 31st, we can look at pages 179 and 180 of the transcript, particularly line 16. The court inquired, I don't have a ruling on plaintiff's motion eliminating number 41. Mr. Kemp, 41. Mr. Pepperman, it's moot. Mr. Kemp, excuse me, I have that as moot. Mr. Odou, yeah. Mr. Rasmussen, so does that mean withdrawn? Mr. Odou, that was Real Water Tennessee. Mr. Kemp, yeah, that was Real Water Tennessee, which became moot when they got their summary judgment. Mr. Neale, moot, so it's okay. So obviously at the time of motion eliminating number 41, not only was there an agreement it didn't apply to Real Water Gold Coast because it's not mentioned in the motion, but that motion eliminate to basically hold this third-party claim in abeyance was withdrawn or as moot, which was acknowledged by Mr. Neale. So I understand that plaintiffs have now announced that they have a assignment of rights, so to speak. I'm certainly willing to look at that and discuss it with my client, who I can't reach today anyways. But I did want to supplement the record with the way this came about. Finally, I would just add, and I think we talked about this last time, Real Water Gold Coast and the other Real Water entity settled with Mr. Haley. So the only claim at issue that was apparently assigned is the claim of Mr. Belsky. Mr. Belsky resides in Nevada. The evidence was overwhelming that Real Water was not shipped to California for Real Water Gold Coast, who only distributed 5-gallon water, so we're not even talking about the retail water. There's absolutely no dispute that this is 5-gallon water. There was testimony from Anthony Brown that he believed he may have seen a truck with water from Real Water Gold Coast come back to Las Vegas. That still doesn't get the water from, first of all, it makes no economic sense that the water was shipped to California to be distributed in California, and that full bottles came back to Las Vegas to be distributed in Las Vegas, and that those full bottles were distributed in Las Vegas. sued Mr. Belsky in 2018. There are additional issues, but I have no problem holding this over and perhaps even briefing this issue. I just don't want to waive it, Your Honor.
I understand, and that's what we'll do. And I guess next, we can hear from Mr. Neale, and I don't mind saying this on the record because I think I said this when this issue came up. And I took a very cautious approach as it pertained to the third-party complaints in this matter. And I think I made a comment because when the issue was raised, the first thing I did reflect on, I think I said this in open court. I said, well, you know, Mr. Neale is a pretty talented lawyer and litigator, right? And so I instinctively, if he wasn't being involved in the case at that level, I kind of thought something's going on because, and I understand this, I realize Mr. Neale did not necessarily prevail on some of the substantive issues, but that doesn't mean he wasn't a talented lawyer and so on, because the facts are the facts. And my decision was based upon the facts and had nothing to do with his ability, because he's a talented lawyer. There's no question about that. And that's what jumped in my mind. And so I felt there had to be something going on, because Mr. Neale didn't strike me as the type of lawyer that would just walk away from the case unless, you know, something was going on behind the scenes. But in light of that, Mr. Neale, if you're on the line, sir, you can go ahead and make your comments for the record, sir.
Thank you, Your Honor. I appreciate the kind words. I'll order a copy of the transcript so that I can distribute it back here. Your Honor, the court took this matter up and I think largely decided it on August 30th when it was ruling on the Real Water Tennessee motion for summary judgment. I've got the transcript and I'll show the court in a moment. But that discussion turned into a decision from the court about how to handle all of the cross claims and all of the third party claims in court in this case. And just to refresh the court's recollection, I know the conversation so far, and maybe this motion pertains primarily to UNFW's third party complaining against Real Water Gold Coast, but there was a parallel third party complaining against Real Water Tennessee, and there were cross claims against the Real Water entities, Real Water Inc. and Affinity Lifestyle. And those are all equitable claims, Your Honor. They were all for equitable indemnity and contribution. And we made the point when discussing the equitable claim against Tennessee that they weren't to be decided by the jury. And you may remember that the court reminded all of the lawyers about the way third-party practice was typically handled in construction defect cases. And that there was always, or at least usually, if not always, a phase 3, so to speak, a compensatory phase, a punitive phase if necessary, and then a third party phase. And that's exactly what we decided on, or what the court decided on, we all agreed to. If I could briefly, I'll try to share my screen, Your Honor, I think it'll come through.
And you know what, Mr. Neale, hopefully it does, but I can tell you this, that sounds something like I would say. I don't mind saying that. It sounds like something I would say. I don't remember with computer-like recollection of every statement I make, but from a historical perspective, it makes a lot of sense. But go ahead, sir.
And you may remember, Your Honor, Mr. Schumacher and Mr. Kavanaugh you had expressed your intention to grant their motion for summary judgment without prejudice, deferring to the bankruptcy court on the interpretation of its order. And you invited UNFW to come back to you after the proceedings if the bankruptcy court ruled that its order of substantive consolidation merged the debtors' estates into one, that is, treated Tennessee and Real Water and Affinity all as one entity. And we made clear at the time that you would hold that order in abeyance, and that Real Water Tennessee didn't have to sit through the trial. And then that discussion morphed into a discussion of the third party and cross claims generally. Because of course, Your Honor, none of these claims even accrue until after a verdict and after a payment is made in terms of contribution or equitable indemnity. So we're looking here at page 63, and if we go to page 67 of the complaint, of the transcript, from August 30th. Mr. Kemp speaks up and says, in reference to his motion to eliminate 41, that Mr. Odou just talked about, this is why we propose that all of these equitable indemnity issues would have you be decided after we do the compensatory and punitive some sort of third phase. And the court concurred and said typically when it comes to all the indemnity and contribution or whatever claims, they're typically not ripe for adjudication. And I agree. And the court continued until there's a verdict entered in the case. And we were all of like mind at the time. And that's when the discussion, Your Honor, page 68, then got into the construction defect world. And you inquired of Mr. Kavanaugh whether that was not his experience, and Mr. Rasmussen whether that was not his experience, and everybody agreed. And so on August 30th, Your Honor, it was made clear to me that the court was exercising its rights under Rule 42B, was sever those proceedings and come back as a phase 3. Subsequent to the verdict, when we would know whether there were indemnity and contribution claims to be had. So I'll stop sharing the screen for now, but that's the reason that Real Water Tennessee didn't participate in the trial. That's the reason why UNFW didn't participate in the trial, and that's the reason why the cross claims and third-party claims remain viable and remain to be decided if necessary in a phase 3. I'll just remind the court, all of these have been asserted in the bankruptcy court, and all of them are to be adjudicated there. There's a settlement conference scheduled. Whether or not we can resolve it there, I think remains to be seen. But that's the procedure on which I think we all settled August 30th, and that's the procedure on which I'd ask the court to continue course.
And thank you, sir.
Your Honor, just to respond to that, Your Honor, we've had motion after motion about omissions by UNFW in this case. And it's astonishing at this late stage, after 8 out of the last 9 weeks, that we get more omissions from UNFW. It's fairly outrageous at this point. As the court will note, I was pointing out the transcript the next day and the motion. Moreover, Mr. Neale just directed the court's attention to the transcript in the 60s. So if we pull up what happened next, which for reasons that I do not understand, UNFW just omitted from this court, we will see on page 74, we came back to motion in limine number 41. If we look at the bottom of page 41, we will see that the clerk again prompted us on page 74, this is after the section Mr. Neale just cited that Mr. Neale omitted. So 3 and 1 of plaintiff's motion to eliminate number 41 are all moot. Question. Next page. I don't know if it's moot. I think we need to understand a little bit what we're going to do here, Your Honor. And then the very next day, we talked about it and it was moot. So for UNFW to again omit a material fact after omitting the material fact that they sold water to Mr. Belsky and paid cash and trying to deceive him, it's just further troubling to Real Water. And maybe this issue also needs to be addressed in Mr. Neale's pro hoc, because apparently we just can't be candid with this court. And that is troubling, Your Honor.
Well, Your Honor, if I may, the reason motion to eliminate number 41 is moot is because the court decided we were going to have a phase 3. What the relief sought in the plaintiff's motion to eliminate 41 was to keep the third-party claim out of the plaintiff's case, just as has occurred. This is not an issue of candor with the court. I'm dumbstruck by Mr. Odou's argument. The court decided there would be a phase 3 in which the equitable claims were to be decided, if necessary, after compensatory and punitive damages.
We would challenge UNFW to point to a transcript or an order. It's just outrageous. We talk, this court's very well aware of how we deal with construction defect cases. This court's well aware that third parties participate in construction defect cases or there's a lawsuit filed later. Instead, what we have is UNFW trying to split claims, trying to argue that they're going to pursue this claim in the bankruptcy court. Maybe they are, but they tried to pursue this claim here. We asked them to let it go. They say they want to hang on to it, whatever that means. They knew they had to be in front of this court, and now they continue to claim that there's some mystery order or agreement out there that doesn't exist, and that's just improper, Your Honor. And now I believe we do have to brief this issue because now it's gone beyond just a quote-unquote misunderstanding.
Judge, if we're gonna brief this issue, can we at least get the third-party complaint fixed and on file to reflect the fact that we're real parties of interest? I don't see how that hurts.
Yes,
Well,
we can.
it's prejudicial to real water because the case has been submitted to the jury. How can Gold Coast defend this new claim? So I think we're gonna have to brief that too.
Well, you know what we'll do.
Motion to amend, or what do you
Yeah,
do?
I think you gotta file a motion to that. I'm sorry. I'm usually pretty easy about this stuff, but I think we need a record. I'm sorry.
Judge, I'll file a motion to amend the OST and try to get this sheet up for next week.
Right. And what I'm going to do is this, and I think this is really important. Number one, I'm not going to make a decision today. Secondly, this is of grave concern from my perspective because I don't want to make a statement or leave a false impression that lawyers can't rely upon the statements I make as a trial judge. I mean, that's critical, I would think. And so anyway, we can tee it all up. I mean, and I did make those comments regarding the equitable indemnity and or contribution claims, and the record says what it says. And I don't have a computer-like recollection that remembers specifically saying that, but it's in the record, and it sounds like something I would say, right? And I don't mind saying it. And I've been told by lawyers, whether you agree or disagree with my decisions, one thing I do try to do is this: I try to be honest to the law. And this is my point. I've had lawyers in front of me, and as an issue comes up, and I said, well, you know what, I think I would probably do this. They're looking for some guidance, and they'll say, well, Judge, that's exactly what you did 10 years ago, right? And so, you know, when you're a trial judge for coming up on 18 years, there's a lot that I've said over the years, and lawyers are really smart, and they go back and they'll pull that, right? They do, you know, and I respect that, but I think, and all I can do is try to, you know, it's like telling the truth. Everybody understands what that means. If you tell the truth, you never have to worry about down the road being a change. And I think it's important too when you look at the law. If you just try to follow the law in its current set, you know, how it currently is set forth, and whether statutorily, case law, or whatever, and you make a comment, maybe 10 years down the road, and someone says, well, Judge, that's what you did 10 years ago. That's kind of like telling the truth, right? We can all agree. And so, Mr. O'Neill, thank you for appearing today. And what we can do is this, post-trial, and I just want to make sure I'm really clear on this issue. The parties are free to do whatever they anticipate would be in the best interest of their clients. How's that?
I'll file a motion to amend on an OST. I mean, I'm not trying to get any kind of waiver out of this, I'm just trying to get in there with the real party.
Yeah, well, I understand it. What we want to do is we want to, you know, and I understand this is an adversarial process, so on and so on. And at the end of the day, what we're going to try to do is what's right. If I make statements, lawyers should be able to rely upon those statements. I don't mind saying it. I'm going to look at it through that lens.
33 pages.
Important to look at what the current case law might be, and also statutorily and procedurally. We'll look at all that, based upon what's presented to me. How's that?
Sounds good, Your Honor.
Okay, let's move on. And Mr. Neale, it's a pleasure, sir.
Thank you, Your Honor. I'll sign off now. I appreciate the court's time.
Okay, so I guess where do we go? Which one do you want to argue first?
Thank you, Your Honor. Would like to look first at Hanna's motion to dismiss the cause of action number 7 of this complaint. That particular cause of action in the second amendment complaint has to do with inherently dangerous. product based on it appears design or manufacturing. The plaintiff's sixth cause of action has to do with the warnings. So 7 it's inherently dangerous. They've already said that in the 6th. It's like, you shouldn't be able to say the same thing twice, otherwise why would you have 2 different causes of action for doing the same thing? The 7th cause of action has to do with that. I believe it's something about cleaning the meter. It's not something that was evidence in this case. Maintenance was not an issue in this case. It is about the warnings. 7th cause of action, we believe there, or as argued, and we have cited NRCP Rule 50.81 for its standing order requirement that a party that has been fully heard on the issues during a jury trial, and the court finds that a reasonable jury would not have a legally sufficient evidence based on the finding for the party on that issue. And that's citing the Nelson versus Here case, 127 Nevada 217, the 2007 case. The district court may grant a motion for a judgment as a matter of law if the opposing party has failed to prove a sufficient issue for the jury, and that's what we believe has happened here. Again, citing the same Nelson versus Here matter. And I'd like to make this a record on that 7th cause of action. Plaintiffs incorporated is that the MW5 is an unreasonably dangerous product. This is the 7th cause of action because consumers expect that the MW would not give accurate readings when used for negative orth readings, or that the MW would not give accurate readings when used for negative orth reading measurements unless vigorously cleaned every 30 days. And I'm trying to figure out how that's different than a warning, since this was a warnings case. And it's inherently dangerous under those grounds. That's my argument on that one. We don't think that there's been evidence with regard to cleaning, and the other one would have to do with accurate readings. But it's not inherently dangerous for that. Finally, we'll tell you that Mr. Motley, plaintiff's expert on warning, says he did not find it to be inherently dangerous. He said that on the trial stand, and therefore we believe that particular cause of action should be dismissed. That's all I have to say.
And as far as the amended complaint, what date was that filed again?
Yes, Your Honor, I believe it was March of this year. I'll give you the exact date. March the 9th, 2023.
And so I want to make sure I'm clear, because I'm looking here. So you got it. Is that the same? Okay, go ahead. So anything, I'm looking right now at the 7th cause of action.
7th cause of action, yes. So the 6th cause of action has to do with warnings, which this case has been about. This one has to do with it's inherently dangerous. It speaks about cleaning, as I just indicated. Also says it's inaccurate readings. But inaccurate readings, we had this one. That's not why it's inherently dangerous for that. It's inherently dangerous because the warnings were bad. That is what the plaintiff's case has been about. And then we didn't warn about this, but now it's something else. So with that, we'll submit that one. And I'm done.
Rob, you joining that, or where are you at?
I'm sorry, on that particular motion?
Yeah.
No.
Well, Your Honor, when we filed a motion for summary judgment in the 6th, I think we made pretty clear that we were pursuing the failure to warn and the Richard applied warranty case, and we were not pursuing unreasonably dangerous. So that issue technically has not been submitted to the jury. That's not on the verdict form, whether or not the product's unreasonably dangerous. Number one. But with regards to Hanna, I think that's kind of moot because there's already been a determination that they're liable. So I don't think we should be filing Rule 50 motions with regards to liability theories on Hanna when they've already been determined to be liable because of other reasons. So, I would argue that we shouldn't be, I would put on the record again that we did not tender the unreasonably dangerous theory to the jury. I don't know when we want to strike cause or claim number 7 because I think it pertains to Milwaukee because it does set forth the same facts that would support the implied warranty claim. But if Mr. Rasmussen's intent is to get rid of the unreasonably dangerous theory from the record, I can say again what I said in summary judgment hearing, that we are not pursuing that claim and have not pursued it.
Your Honor, the court never made its ruling on this. We did tee it up to be done then. We actually filed this motion before the judge made his ruling with regard to us on your finding on the compensatory damages, but this can't be a part of the compensatory damages. So you're getting the record clear that this is not something that the jury should be considering.
But I don't want to cut you off, and this is my question. I don't think the jury considered this issue, did they? In light of the jury
I don't
instructions.
know.
No, we should know that, in light of the jury instruction and also the verdict.
So there are many instructions that went back to the jury with regard to implied warranty and things like this, which is where this is at, and it's not a cause of action against Hanna. So I don't know the answer to that question. We'll have to ask the jury afterwards. But it doesn't differentiate on those questions that, oh, this is against Hanna and Milwaukee. We don't know that.
Well, Judge, we didn't.
We didn't, I apologize, we didn't instruct them as to which, but I think there could be confusion with regard to this, and I want to make sure that the court, as a matter of law, has said, if a jury returns and we find out, no, we decided this as well against Hanna, then I have something to work with.
Yeah, but here's my question, and it's really this simple.
Okay.
When we submitted the jury instructions and verdict form, they weren't requested to decide this specific issue.
As to Hanna, you're right.
Right?
Or to Milwaukee.
Yeah. No, but is it true or not? And there's no need
I'm
to-
not saying that. You're right. I'm just concerned about confusion, and I wanted as a matter of law, that's why we did this before the jury received the case, that the court had found this cause of action to be not against Hanna.
Well, Judge, I don't know that the Rule 50 motion is the appropriate way to do this, especially after there's been a liability determination.
I don't know what other rules I can use in the rule book that allows me.
Well, if the jury supposedly renders a verdict for us unreasonably dangerous, and you can establish that without violating the rule about jury affidavits and everything, I don't know how you could. But if you can, the appropriate remedy would be a motion for relief under Rule 60, probably.
But I'm coming back to, and as far as the verdict forms are concerned, where does it say they were asked to answer that
They
question?
weren't asked to
They were not, Your Honor. So then as a matter of law, we're saying this cause of action, if it wasn't, does that mean the court is saying as a matter of law, since it wasn't sent to them, then as a matter of law, this motion should be granted because it's not a part of this case? This is what I'm asking for, just as a matter of law. What does the court believe? Because if you did send it to them, then is that, in essentially, are you basically saying that this is, as a matter of law, not being a cause of action that could have been submitted against Hanna?
Well, I mean, a couple of things. Number one, remember this, when it comes to both the jury instructions and the verdict forms, I didn't prepare those, right?
I agree with that.
The lawyers, and so it's not what I'm saying. I can say this, that if hypothetically, I'm looking here, seventh cause of action, unreasonably dangerous against defendants, and Hanna Instruments and Milwaukee Instruments. I mean, I haven't gone back and looked through the allegations, but this is a really important point, because I want to make sure from a legal perspective, the record's clear. There's three types of product defects. We know that, right?
Yes,
It can be a design defect, it can be a manufacturing defect, or it can be a defect based upon fatal warrant.
Yes.
Notwithstanding all that, they all come under the umbrella of defective product and reasonably dangerous pursuant to restatement of 442A.
Yes.
And so,
And the The sixth cause of action talks about the warnings. So it's not-
Right, and so, and here's my point, I mean, it's, go back to the seventh cause of action says unreasonably dangerous against defendants Hanna and Milwaukee, right? And so my question is this, and it's, I think it's a valid question. It doesn't matter whether it's a warning case or not, it all involves allegations of an unreasonably dangerous product pursuant to restatement of torts. And so what else is there in the seventh cause of action that I should be concerned about? Because, for example, a design defect issue wasn't submitted to the jury to decide. A manufacturing defect wasn't presented to the jury. But when I read the seventh cause of action, it just seems like they're saying that the product was unreasonably dangerous. I mean, what,
I don't know, I mean, I don't.
I'm trying to figure out-
Mr. Rasmussen for not wanting to be snake bit on appeal, but I don't know how I could possibly do that when in the motion I'm saying we're not pursuing that claim, when we didn't submit it to the jury, okay? So I just don't see how he gets snake bit on appeal on that. And so I said it in the motion, I said it at the hearing, I think I said it when we submitted the jury verdict form. I'm saying it again today, I just don't know how he gets snake bit under those circumstances.
Your Honor, I have been snake bit in this case several times, and so I need to make sure that I have a clean record with regard to this particular, because there will be an appeal in this case most likely, and so I need to make sure this seventh cause of action as a matter of law, and you can rule against me, Your Honor, that's fine.
no, it's not a question of, well, I mean, my point is, it's moot. It wasn't submitted to the jury to consider.
Agreed.
But I'm looking at it here too. What is it really saying? And that's what's important as far as, because when I look at the seventh cause of action, it says, what is it, other than alleging a defective condition unreasonably dangerous?
Right, so that's almost manufacturing. In other words, it was put out in such a manner that it required cleaning. That's what it says in Part B of, I believe, paragraph 168. I think part-
168?
Yeah, isn't that what it says there? Yeah, or to number 2, I'm sorry, it's Part B to that. Part 1 is the same thing, did not give accurate readings when used for, but remember, that cause of action is gone. In fact, Dr. Motley said on the stand, said it's not an inherently dangerous product.
He can't say, but it can, this is what I want to make sure the record's clear. The jury is going to decide right now whether or not this is a unreasonably dangerous product.
I agree with you. They are with regard to the warnings.
Right.
With regard to the warnings. And that particular cause of action is cause of action number 6.
Okay, now I'm looking here, and I just want to make sure. What is, here's my question, and I just want to make sure I'm quoting this. Does paragraph 7 allege, I'm sorry, the seventh cause of action, does that allege a design defect?
It's either design or manufacturing.
No. Does it, I want to make sure I'm clear on this.
It's standard consumer expectations test language.
Right. And for example, I mean, it says unreasonably dangerous. All 3 potential theories come under that. And so my question is, I'm looking here, and it talks about the ORP meter does not give accurate readings when used for negative work measurements. That's all part of the claim that they failed to warn on
Yes.
that issue, right? Then number 2 says the MW500 would not give accurate readings when used for negative work readings unless rigorously cleaned every 30 days. Okay, that goes part of potentially the failure to warn. But I'm looking here, does it say that as a result, this product was defectively designed or improperly designed, or does it say it was improperly manufactured or something like that?
I do not see the word design or manufacturing, so if it doesn't go to that, and the warnings is covered in the 6th cause of action. Okay, I'll let Mr. Parker go ahead and address it. He needs to.
No, I was talking to Will. I wasn't trying to slow you down.
No,
I was saying, Will, let me address this.
Okay, I'll let Mr. Parker go ahead and address it.
No, I can't remember, I think I was in federal court, and a judge was telling me, and I think I had this conversation outside this courtroom in the hallway with these two gentlemen over here. And it's amazing how you can put headings to causes of action that really just identify similar facts that prove really your general allegations. We have a jury instruction number 27. Jury instruction number 27 says a product is unreasonably dangerous if it fails to perform in a manner reasonably to be expected in light of its nature and intended function, and was more dangerous than would be contemplated by the ordinary user having the ordinary knowledge available in the community, which is
Consumer expectation.
Thank you. And that's what Mr. Kemp was trying to say. And what I think Mr. Rasmussen is getting lost in is trying to, perhaps not lost, perhaps what it is he's thinking that this separate cause of action, for some reason, identifies a manufacturer and design defect, which we're not pursuing. We're saying is unreasonably dangerous because of the consumer expectation test, which is under C-Ray, I believe, and because it's unreasonably dangerous because of the lack of proper warnings and instructions. That's the issue here, and that's what's been presented to the jury. So I believe Mr. Kemp addressed the technical reasons why we didn't bring a design or manufacturing defect, but it still comes under this jury instruction because it is unreasonably dangerous without the proper warnings or instructions. Now, I don't know why Mr. Rasmussen believes he needs this cause of action dismissed, because it doesn't change what went before the jury, and it doesn't affect the ultimate outcome, especially since liability's already been determined. So I think, again, this is, I hate to say it, but I think we've said it too many times in this court. It's a distinction without a difference in terms of what we're pursuing, and given that you agreed to jury instruction number 27, I think it really renders your motion moot.
Well, and I think this is important to point out though, because we're asking to dismiss the seventh cause of action, but the seventh cause of action in a general sense is not a standalone cause of action. And my point is this, all it does is this restates strict products liability, unreasonably dangerous against Hanna Instruments and Milwaukee Instruments, and it talks about some of the issues that are tied to the failure to warn. But other than that, it doesn't say anything about design defect or manufacturing defect.
That's right.
And those claims weren't submitted to the jury. And so I'm trying to decide, okay, I mean, for the record, I don't mind saying this, design defects and manufacturing defects weren't submitted to the jury, right?
That's right.
And they weren't pursued. But and here's my point. I just don't want to take out the underlying basis when you talk about unreasonably dangerous product pursuant to restatement tort 42A, and that's all you say, because I'll be really candid with you. When you talk about it, the seventh cause of action is just an extension of number 6.
We didn't even need to have separate causes of action. It's all one claim. And again, Mr. Rasmussen agreed and approved jury instruction number 27. I don't see where this motion is appropriate from.
And you get the last word. So I don't mind telling you this, there was no claim for design defect or manufacturing defect submitted to the jury. The only issue that was submitted to the jury was essentially this, a quote, failure to warn case based on allegations that the product was in a defective condition, unreasonably dangerous, as set forth in paragraph 157.
That's right.
And then you incorporate by reference, right? That's the case. And so if I'll give you, we can move to the next one. I'll give you some solace that I don't mind saying it. There was no evidence of a design defect and or manufacturing defect submitted to the jury. The only issue submitted to the jury focused on a product defect based upon one, failure to warn, and also and implied warranty fitness for a particular purpose. Those are only two issues submitted to the jury.
Thank you, Your Honor. We will just submit number 6 on, to the court, but we don't expect it to be granted by the court based on what you've just said, so I don't want to waste the court's time in arguing that particular one. It is submitted to the court on the brief.
Okay, and that's,
With regard to the 6th cause of action, with regard to inadequate warnings, because, okay? Last one has to do
but no,
with.
you can make a record on it. I don't mind saying this, because when it came to the adequacy of warning issue, the plaintiff presented an expert witness to support that specific issue. He testified.
Yes.
And ultimately, that became a question of fact for the jury. And in a general sense, they met their burden.
I agree, Your Honor, but please understand, it was Milwaukee that placed the tip card into the box to be sold to Real Water. Now, that tip card, as everyone knows about, says what it says, but Hanna did not do that. Hanna wasn't there doing that at all. And because it appears now that I am now liable for the tip card somehow as Hanna, the only record I can make is, why should I be liable for the tip card when no one at Hanna did anything about that? Okay, this was created by Brian Moore. He has never been an employee of Hanna at the time the tip card was put in there. So this then comes to what the court described the other day was the 2 hats of Carl Salvaggio, who is, as has been discussed, the facilities vice president at Hanna. So somehow, because of that, he's now brought some sort of vicariously Hanna into this mix on a tip card that was created by someone at Milwaukee and is used every time they put it in there. But there was no evidence of decision-making by Hanna. There is nothing about this warning that Hanna said, oh yeah, we're totally good with that. We have the president of Milwaukee saying, yes, I approve it and it was done. That's it. It can't be that, oh, I did that there, so it must be something true for Hanna as well. Nothing like that happened, because the failure to warn has to do with that, and that alone, because when it talks about oxidation, that's where it's discussed. And what Dr. Motley said is, I want what's on this tip card. This was his criticism. I want that in the instructions itself. Okay, so the instructions that's created by Milwaukee on their own should have been in there. Not that the instruction itself was bad, he couldn't testify to that. He says, I don't know if it's good or bad or not. So we've heard a lot of stuff about that it doesn't work, but all the evidence on that is with, again, Jason Brown, not my employee. And so the 6th cause of action, I made what I can of the record, is that somehow I'm being brought into this as a distributor for a card I never distributed. It was distributed after the box gets to Milwaukee. I'm not distributing that card. Okay? So that's my record. Thank you.
I understand, and I'll just give an explanation. You're in the distribution chain.
Yeah, that's the easy one. Your Honor, can I substantively
Of
respond to
course,
that?
I don't.
Your Honor, I was surprised when defendant's own expert, Dr. David Fortenbach, indicated in his testimony on September 28, 2023, that the best practices were required not only Milwaukee to have it in the tip card correctly, but also in the owner's manual. Hanna's responsible for the owner's manual. So he can't escape responsibility by simply pointing at Milwaukee, Mr. Robbins' client, when his client put the owner's manual in the box before it came to the United States. So Hanna's responsible for the owner's manual. Milwaukee is certainly responsible for the tip card. It was great that we got Dr. Fortenbach to say that. And if Mr. Rasmussen is concerned about the page, this is page 196 and 197 of the trial transcript I'm reading from you. So I think that his client is up to their waist in responsibility for the owner's manual, which didn't have the proper warnings, instructions, oxidation requirement, recommendations, anything. And best practices would have been to include it in both.
But with not even going into that issue, right, as far as the evidence is concerned. They're in the chain of distribution.
They are, which is another jury instruction that was approved.
I mean, it's, and remember this, and this is overlooked, and this is the real fundamental of strict products liability from a policy perspective. The thrust and focus is not on the conduct of the parties, right? The thrust and focus is on the product, and whether the product is in a defective condition that needs to be dangerous. And our Nevada Supreme Court had an opportunity to take a look at that specific issue not long ago and make a determination as to whether or not they're going to continue following the consumer expectation test versus risk utility analysis. And from a policy perspective, Justice Stiglitz said this, and I'm just paraphrasing, but Nevada saw no reason to continue with the consumer expectation test. And so, and it kind of makes sense because when you look at it from this perspective, from a policy perspective, it was putting too much of a burden on the plaintiff. It just was. Because the sole focus should be on if there's allegations of a design defect, okay, let's focus on that, right? On the product, not whether they made their good faith efforts or any of those things. Is it an effective product and reasonably dangerous? Is there a manufacturing defect? Same analysis. And then you go to the warning issue. Conduct of the parties never matters. And I know why it's saying that, it's saying this because that was one of the seminal issues in a McCourt case. Because you had two great lawyers, Mr. Goldwater and Mr. Gallas, who I worked for. And I remember, I wasn't working for him when the case was tried. I came on board right after the trial. And I remember it was hammered to me. And that's why I think products liability became so clear. The defense in that case was, what did we do wrong? It was just, I don't mind saying it, it was nightwear for a child, you know, and it wasn't, there was no flame retardant as far as the manufacturing process. And there were arguments made by Mr. Goldwater that, you know, they'd been washed so many times and this and that. And all we did was sell a product. You know, we didn't do anything wrong. We just retailer, J.C. Penney's. That was the argument, right? And it was an improper argument to be made in front of the jury. And that's what our Supreme Court said. And I don't mind saying I was a very, very young lawyer, and that struck me from that point on, and as far as products liability. And I think what happens, sometimes we get a little misdirected on that issue, right? It's all about the product. That's what it is, the product. It's not what we were intended to do, or we made a mistake, or no, there's no negligence concepts involved at all. Zero. And so anyway, I don't mind saying it. I'm gonna deny the motion. I think the record's pretty clear as to the current status of the evidence. And there was a triable issue of fact here. That's probably the best way to say it, and it's going to be resolved by the fact line. Let's go to the last one.
That's on punitive damages, Your Honor. We appreciate your ruling on the second of our Rule 50 motions. This one has to do a lot with what has been presented to the jury with regard to any sort of communication between Hanna and the plaintiffs who were injured. So I understand chain of distribution, but that's not what's required under punitive damages. It literally requires some sort of a way that what we did caused the plaintiff's injuries by clear and convincing evidence. Let me just state for the record what I don't believe has happened yet. There was no evidence by the plaintiffs that the user manual was not updated for 35 years. It has been, that we provide that evidence. Number two, there's no evidence that Hanna knew the MW500 would give inconsistent readings when measuring negative ORP readings. None of that exists. The only thing they've got is that this Carl Salvaggio, Mr. Salvaggio does know this. Okay, but Hanna doesn't know this. He's the facilities vice president. And this wearing the two hats doesn't give me clear and convincing evidence, because no evidence was put there that in any way did he ever share anything with Hanna Instruments Inc. with regard to that. Hanna did not promote the MW500 because it's not in our catalog, it's not on our website, it's nowhere. It's not something that we sell. It's an exclusive contract where we only give it to Milwaukee. Number 4, Hanna just never received any of the complaints that Mr. Brown talked about extensively in his deposition testimony. Mr. Brown, as we both know, is not a Hanna employee. It's not like we're listening to anything that Mr. Brown from Milwaukee does with regard to this meter. They're not CC'd back to someone. In fact, there's no CC about them at all, what Jason Brown is doing. So we can't be, again, vicariously liable. I think that was the one area that I wanted to make sure that the court was aware of. We cited the case law of Wyeth that speaks to these things. What's the standard for this stuff? And vicarious doesn't work. It has to be substantial evidence that Hanna did something. Not that Milwaukee did it and therefore somehow Hanna should be found liable for it as well. As a matter of law, we don't believe, based on the standards for this, that Hanna did anything with malice. Mr. Salvaggio didn't talk about doing things with malice. And that anyone at Hanna did anything with malice. That they were oppressive at Hanna for all of the things that may have been done at Milwaukee. That's not Hanna. There's 2 different corporations here. Now, the court has said that, well, he wears 2 hats. Therefore, whatever he was doing, if it was oppressive or malice or whatever, that must have also been true for Hanna as well. And I don't think so. We don't think that's the law at all. And there's been no case law that says if you're wearing this dual hat somehow, you're now part of Hanna's doing it as well, as the vice president over facilities, who basically makes sure the warehouse is clean with his 2 employees there, that's what they do. Repeatedly we saw these, during this trial, the word CEO that came up for Mr. Salvaggio. That's just not true. That wasn't the evidence. That was the things that were being said by the plaintiff's counsel in their closing and their opening. Those were factually inaccurate. They were wrong. They shouldn't have done it. Because he's not. And he testified as such as the evidence in the case. So I'm trying to figure out where there's clear and convincing evidence that Hanna, in the chain of distribution only, which is not the standard here, is somehow acting in some punitive nature as to these specific plaintiffs and their injuries, okay? Because that's what you have to say, is that we did something to the plaintiffs, not that we did something to Real Water even. It's the plaintiffs. We went over each one of them, malice and all of them, yesterday as to what they meant. There's nothing about Hanna doing those things. We're not the ones doing these things. And the evidence is all about what they did. And it's not like Hanna had some, and there's been no evidence of some committee that said, oh, yeah, we approved the tip card. That didn't happen. Okay? There's been no evidence of that. There's been nothing that's clear and should be convincing to anyone that that happened. With that, we think that the punitive damages, and so over to the verdict, is over to the jury, we get that, but we think as a matter of law, this court should deny, or should grant this motion and deny any punitive damages against Hanna. Thank you.
You're welcome. Your Honor, this is, I'm trying to hold back the laughter. Your Honor, we've seen now Hanna go from blaming Real Water for everything, now to blaming Milwaukee for everything. It's amazing to me, given jury instruction number 29, that Mr. Rasmussen would make that argument. Hanna is in the stream of distribution, in the stream of commerce. They put this out there. It says, paragraph number 1, jury instruction number 29. Product manufacturers, distributors, and sellers all have an obligation to provide their products with warnings that adequately communicate any dangers that may result from the product's use or foreseeable misuse. There, as far as Milwaukee is up to its neck in alligators on this issue, so true would be Hanna. So I don't know where he's missing or is failing to understand what these jury instructions provide and what the law of our state is when it comes to manufacturers, distributors, and sellers of products. Jury instruction number 47. Conscious disregard means a knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to act to avoid those consequences. Your Honor, as we believe that more than enough evidence has come before this court and this jury to indicate that Hanna and Milwaukee should be held responsible for the product. And we believe that they've shown a conscious disregard to the safety of these plaintiffs. I agree with Mr. Rasmussen in terms of the burden of proof. That's in jury instruction number 48. But with everything else, and I'm trying to make this quick, Your Honor, the jury instructions stand against his proposed motion, and the evidence certainly does.
Your Honor, if I could respond with, okay, I'm sorry, Will, apologize.
Yeah, Your Honor, I don't begrudge Mr. Rasmussen, he's just doing what he ought to do, because he's got to file a Rule 50 motion to preserve his motion for judgment on these, so obviously he's got to do that. But we fleshed out this issue pretty thoroughly in the summary judgment motion, the filed motion for summary judgment on punitives. I'd like to incorporate our opposition, since we filed written one to this one. I'd also like to incorporate the argument that were made at that time. And specifically, if the court recalls, we focused on the Wyatt case, Judge Cherry's decision. And that was a case where Wyatt had one warning in Europe and they didn't get the same warning in the United States, and the vast Supreme Court held that was sufficient to tender punitive damages to the jury. In this case, they had one warning for the conditioning kit, that it was that the condition it would be inconsistent. They didn't put that warning in either the user manual or the tip card. So under Wyatt alone, you would get there. Countrywide, we would submit there were a number of red flags here. They got complaints from lots of customers. People were confused. They knew about inconsistent results. We admitted those emails. They didn't do anything about it. And the reason they said they didn't do anything about it is, we can't change it. I'm from Romania, we can't do anything. That was the most, I think, stunning admission in the whole case. They didn't do anything whatsoever to satisfy the obligation to provide a warning, because they said they tried to delegate it to Hanna, Romania. And then we find out that Mr. Savaggio goes back and forth to Romania 100 times and he never wants to talk to him about it. For those reasons, I think we've made an adequate showing. With regards to this suggestion that Mr. Savaggio, who's the president of Milwaukee, all of a sudden has his mind scrubbed the minute he walks back into his Hanna office. Anything that Milwaukee knew about these complaints, that since he was the president of Milwaukee, that went right back to Hanna, because at the same time he's the chief operating officer. You can't just say, we didn't know about it, only Milwaukee knew about it. So all those red flags, I think, fall squarely on Hanna's shoulders as well. And for that reason, Your Honor, I don't begrudge Mr. Rasmussen. He should file this motion. He's got to preserve his record on for the JOB and on appeal. But for those reasons, I would think the motion has to be merit.
Just to be heard really quickly, what the Wyatt case does not include is some sort of vicarious responsibility. That particular case has to do with what's going on over here, and the retailer that was over here for, I think it was breast augmentation or breast, something to do with
breast implants.
breast implants. I said augmentation, it's probably the wrong word for it.
Well, at least it is augmentation.
But it was
I'll
only.
ask my brother.
I was a liaison counsel in the breast implant case.
So the point is that there's only one defendant over here in the United States. We have two, and so what they're claiming is that there's some sort of vicariousness that lends itself from Hanna through to Milwaukee, to Real Water, to the next one. And jury instruction number 47 talks about, if you want to pull it up real quick, Mark, just so I can see it. And I read this to the jury yesterday. That defendant, in other words, each one of the defendants must be liable on their own. There is nothing in there about vicarious liability from one distributor, or from the retailer to the distributor, to the designer, to the manufacturer. There's nothing like that in that particular Wyatt case. It doesn't exist. It doesn't talk to that. It's open. Now, the court can say what it wants to, and that's probably what I'm waiting to hear, is because then that is something that will be brought up on an appeal. No, this court is finding that vicarious liability does go back. But
I'm not making a vicarious liability decision. I mean, we can't overlook all the testimony from Mr. Savaggio,
okay,
right? He wore two hats, one for Hanna and one for Milwaukee. And he knew all about the sales puffery and all those, because that's overlooked, right? You had
Okay.
the sales puffery issue. You had complaints coming in or questions, and instead of following specifically what was in the tip card or which might have been in the conditioning kit, they were getting all sorts of different recommendations as to how to condition the platinum probes in a time period. And here's my point. Number one, I have not ruled vicarious liability vis-a-vis punitive damages in this case. The jury's going to go back and listen to the facts, and they'll make a determination based upon clear and convincing evidence as to whether or not there's sufficient evidence pursuant to Nevada law as it relates to punitive damages to make that decision. And it's important to point that out because the jury is going to make that decision. My whole issue is this: is there sufficient evidence to go in front of the jury? Nothing more, nothing less. And there's questions of fact there because there was a lot of communication, and Mr. Savaggio knew about it. Now, which hat he had on when he was making those decisions? Did he have on, or we heard the information, did he have on the, quote, Hanna hat, or did he have on a Milwaukee hat? I mean, I don't know, but the jury will decide that. And so my point is this, and it really comes down to one important issue. Number one, I've never made derivative punitive damage type decision. It's going to be decided as to each one. As to each defendant, and that's the jury's decision. And so I just wanted to make sure the record's clear on that because I'm not making that. I have not ruled that. I don't mind saying it. I have not.
thank you, Your Honor.
They're going to decide it as to each defendant.
Thank you, Your Honor.
And it's really that simple. And there was sufficient evidence to go. I'm gonna deny the motion.
Thank you, Your Honor.
And does that cover all motions?
Yep.
Judge, I just should add the record, because sometimes we look back at it, that they did not object to instruction number 47, and they did not propose some sort of vicarious liability instruction. Just want to add the record.
Right. I understand.
Your Honor, we didn't file a written motion, but we wanted to do an oral 58 motion as to Milwaukee, given the testimony of Fortenbach, Babcock, and Carl Savaggio.
Your Honor, may I be heard before Mr. Parker makes his argument?
You can.
There's no motion to be made. It's been submitted to the jury. It really doesn't matter what this motion is. Under 58, you gotta make your motion before it's submitted to the jury. The jury's back deliberating. I don't know what this motion is. Procedurally, there's nothing to listen to, Your Honor. That's my objection.
I understand.
I join in that because Rule 50 does require that this be done before it's submitted to the jury. It says it.
Then tell me this, why did I listen to your motion?
Because we waived that, Your Honor. That was on the record. I asked Mr. Kemp that specifically.
But here's my.
I thought we waived them all.
Wait. From a timeline perspective, I saw this, and it's my understanding, and correct me if I'm wrong, this was filed at 4:40 p.m.
2 days ago before the jury got it. Yes, Your Honor. And I know we talked to Mr. Kemp about that, and it was on the record, Your Honor. I 100% remember that particular conversation, and that was held on the record in front of this court, and the court said, fine, that's what we'll do.
Judge, she's correct, Your Honor. I didn't say that you filed it.
Oh, I understand that, but go ahead. Okay, so now I get it, I do.
I don't think I did anything wrong, Your Honor. I really don't.
This is what everyone has to understand. And I think, and maybe this is something that's problematic to our adversarial process, and then we'll deal with the issue. But as a trial judge, and it's important to point this out, you have winners and losers, and none of this is personal, right? And I don't mind saying it. This is more for the benefit of Mr. Rasmussen, because I look here in this courtroom, I think probably Mr. Parker's tried more cases in front of me. Probably second, Mr. Kemp, and then everyone else. But I remember it was about 10 years or so ago. And Mr. Parker probably remembers this when he thinks back. He was trying an insurance subrogation case in front of me with Mr. Bob Carlson, right? And it was a, quote, subrogation case. I forget who the carrier was. And you'd never see this in a case, and Mr. Parker had a tough role on this case. He really did. Because what the insurance company did was, and it was claims regarding framing, right? And trusts, you represented a truss manufacturer. And then I'll get to my point, which is important. But they had a tough road in that case because you never see this. And I remember the insurance claims adjuster, I forget, one of the major carriers stood up in court, and she reminded me of Betty White. You know, I don't mind saying it. She did. Did she, Mr. Parker?
Oh, yeah.
She reminded me of Betty White, and what was her character in Rose Nyland, right? She had a little bit of that in her. She did. Mr. Parker, didn't she?
She did.
But here, and so here you have a major insurance carrier, and you have, think about this for a second. You have Rose Nyland sitting on the stand saying, well, why did you pay the claims? And Mr. Parker's trying to cross-examine him very aggressively. And this is kind of, and then I'll get to the point. And I think the response was something like this. Well, you know, our homeowners, our policy owners, this is the largest investment they'll ever make in their life. And they had a problem. And we wanted to do what good insurance companies do. We just paid the claim. Something along those lines. Is that correct, Mr. Parker?
That is.
Right? And so sometimes you have cases with tough facts, and that's what Mr. Parker had. But here's my point. And we did some deep digging in that case. And remember, we were looking at issues as to what should be tried from an equitable perspective, what should be tried as a matter of law. Ultimately, Mr. Carlson and Mr. Parker kind of agreed, and we went down that road. But this is my point, and this is an important point. I remember there was one point at the trial where I think Mr. Parker was very unhappy with me as the trial judge.
It happens.
Right? It happens, right, Mr. Parker?
Yeah,
it happens.
balls and strikes.
Yeah, balls and strikes.
You told me that.
And he made a comment, and we're close, and said, is this going to be the way it is, or something like that? Right? Here's my point. It's very important. And if you talk to Mr. Carlson, he'll say, the judge called it right down the line, right? But my point is this. None of this is personal. I respect every lawyer in this room. And you shouldn't look at it that way. Sometimes you have good facts, sometimes you have facts that aren't as favorable. And so when we're done, regardless of what the jury's verdict is in this case, because this is important to point out, and I think Mr. Parker went through, he just had challenging facts. And there were some very discrete and complex issues that we had to address. And I even think Mr. Parker, correct me if I'm wrong, was like 3 or 4 days during the trial approach. He says, Judge, I apologize, you were right.
Yeah.
Right? But you were mad at me. He was, but my point is, none of this is personal. That's all I want to say. You know, and
Your Honor, I don't think anything you've done is personal.
I just want to say that for the record, because sometimes you have good facts, sometimes our facts are challenging. Right? That's probably the best way to say it, challenging. And so on. So I've been there. And as a trial judge, all I can do is call it the way I see it, and if I'm wrong, the jury can, the Supreme Court can say, Judge, you missed this point. But I just wanted to put that on the record.
Your Honor, the trial testimony ended on the 29th in terms of this witness. He finished at 5:15. My notes, I always put down the times of everything we do. And it was my understanding that we were waiving the time period for filing the 58 motions. If I got that incorrect, then I guess it happened, but that was not my understanding. And then on Monday, of course, we figured out what was going on in our minds, what happened with Hanna and the testing, and then we brought our motion, we worked all weekend on a motion to strike their answer. And so, again, Your Honor, I thought we had the additional time. I thought we waived the time to bring it because we were trying to get so much done in so little time. And I simply want to articulate at least why we believe 58 would be correct in dismissing or actually granting the liability in our favor against Milwaukee, given the testimony of the defendant's expert. And if the court ultimately decides against it, that's fine. But I think I'm working under or operating under the understanding I thought we had here.
Your Honor, I would add that Rule 6B provides for the extension of time for good cause that the court may grant. And there are certain motions that cannot be extended, but the Rule 50A motion is not one of those that cannot be extended.
Your Honor, briefly, before Mr. Parker starts, you get lunch first.
Oh, we're not gonna take much longer. I promise you, we'll be going to lunch in 5 minutes.
Okay.
Sounds good. Sorry, didn't mean to.
Sorry.
Our stomachs are
Mr.
growling.
Robbins, sir.
Thank you. That's nice tap dancing over there, but they know they didn't reserve their rights, Your Honor. And I got the video teed up of actually Mr. Kemp standing up, and all he did was waive the timing to hear the motion. That's it, because he wanted to continue his, he wanted to get on with things yesterday morning. So there was no reserving the rights. I would have objected to that. I'm objecting to it now. It's beyond the time. You've submitted all the issues to the jury. They have it. They're in the jury room deliberating now. So if he wants to make an argument, fine. You want to hear it, that's fine. I will not be opposing it. I'm going to stand procedurally on 50A that it's improper. It's after it's been submitted to the jury. There's no reason to hear it. But if you'd like to hear it, you're welcome to do so.
Well, I'll be brief, Your Honor.
Let's keep it brief, because I made a promise.
No, and I want to make sure you keep
5
your
minutes,
promise.
right?
Absolutely. Your Honor, Dr. Babcock testified that the MW500 orc meter, as a part of the process of creating a real water product, was used to determine as the, in his words, the primary determining factor of how much concentrate to add. That's his testimony, September 29th, page 184, lines 21 through 23. Dr. Fortenbach, on cross-examination, said that the tip card did not provide the required 4 to 5 days to oxidize the probe. And he said it does not. This is September 28th, page 193 of his trial testimony, lines 17 through 19. Carl Savaggio, on September 26th, testified that there were no tests performed to determine whether or not the instructions on the tip card were correct. And then finally, Your Honor, Dr. Motley testified that the tip card and/or the owner's manual should have communicated the proper conditioning for the probe. Given that there's no evidence from Milwaukee that the tip card or the owner's manual had proper oxidizing recommendations in it, Your Honor, I think liability should be established against Milwaukee. And I think that was less than 5 minutes, Your Honor.
All right. And this is what I'm going to do on that. And you know what? I don't mind saying it from a timing perspective. I don't think the record is really clear as it pertains to the 58 motions. And so the records, I'll give you fine gentlemen an opportunity to go back and determine what the specific timing would be on that specific issue. But and so I'm going to address it heads up. And I just look at it from this perspective. There were sufficient issues of material fact to go to the jury as far as the potential responsibility of Milwaukee in this case and or Hanna is concerned. And so I'm going to address it heads up. I'm going to deny the 58 motion.
Thank you, Your Honor.
There you go. And you guys can fight about the procedural aspects of it later, but I'm denying the motion.
Thank you, Your Honor.
What was the motion regarding the 7th cause of action? Was that denied?
I'll do it this way.
Well,
Yeah, go
I'm
ahead.
sorry, I want to be heard on that again, Your Honor, because I think it's
In which manner, sir?
on you've considered the motion head on and now you're denying it.
Yes.
And I think that's prejudicial, and I just want to make a record, if that's what you want to do, that's fine. but that allows them to renew that motion post-verdict. And I'm saying, I think the court should rule, and we have, like I said, we can play the video of what was said. All that was waived was the timing of arguing his 3 motions. Nobody reserved the right to file later motions. So I think in doing it the way you did it, maybe inadvertently, you know, they kind of got what they're hoping for, to try and file the motion later on. And you may rule exactly the same way if they did renew that motion post-judgment. But procedurally, I wanted it on the record that I don't think Your Honor should have considered it to begin with.
And your position is well noted. And
Thank you.
it's noted for the record. Absolutely. There's been no waiver of that.
Thank you.
What was your next question?
Regarding the motion for the 7th cause of action, is that moot or denied?
Denied as moot.
Okay.
Because there's really, the 7th cause of action is just a general allegation regarding the defect of public beliefs to be dangerous. And that comes under failure warrant. All right, so we're done? Was it 5 minutes, sir? Not quite. but
Close enough, which is exactly 5 minutes.
Was it exactly 5 minutes?
Your Honor, I had a housekeeping question, how this court does it. Obviously, we want to be back as soon as possible when there is a verdict or if there's a question. Different judges have different rules as soon as possible. I'm trying to figure out if we've got enough time to go someplace other than a Greek restaurant, because Mr. Kaufman has objected to the Greek restaurant.
I understand. Well, there are places downtown. As long as you're downtown, that's fine.
Yeah,
We're just gonna go downtown.
Yeah.
What time do you need us back?
I have no clue on that. I mean, and all I can say is this. I can't give you any, because I have no clue what the jury's doing, but they've been deliberating since about, what, 9:15, 9:30? So, do whatever you think is best, but enjoy your lunch.
All rise.
I mean, the nugget's not very far, you can walk there.
Yeah, we're going to do a marathon, it's just a little bit, takes a little bit longer than the Greek place.
Oh, yeah, it takes.